I'm sorry to cut short this wonderful presentation, but in the interest of time, I want to introduce my colleague, Barry Feld, who is the Centennial Professor of Law at the University of Minnesota, one of the great experts in the country on juvenile justice issues and disparities. Professor Feld is not only a law professor and a lawyer, but also has a PhD in sociology and has edited 9 books and nearly 100 law review articles, book chapters, peer-reviewed criminology, and pieces on juvenile justice with an emphasis on race, serious young offenders, and procedural justice and youth sentencing. His book, Bad Kids, Race and the Transformation of Juvenile Justice, Oxford University Press, received the Outstanding Book Award from the Academy of Criminal Justice Sciences in 2001 and from the American Society of Criminology in 2002. Professor Feld.
I'm an old guy, so I don't do all the technology stuff. So I'm just going to talk for a few minutes about juvenile justice and race and how and the role that race has played in juvenile justice over the past several decades here in Minnesota and elsewhere. And what I'm going to argue is that over the past several decades, the juvenile court has been transformed from a nominally rehabilitative welfare agency into a scaled-down second-class criminal court. And that has occurred because of the 2 distinct roles that race has played in juvenile justice policies over the past half-century. Minnesota got its juvenile court in 1905, and it was a traditional kind of rehabilitative, informal juvenile court without procedural safeguards. In 1967, the Supreme Court decided in re Galt that granted juveniles some procedural safeguards, including the Fifth Amendment privilege against self-incrimination, which began the process of making the juvenile court into a more adversarial and criminal-like endeavor. And one question, that sort of puzzled for a while was, so why did the court decide Galt in 1967? And the answer was it was about race. It was about sort of the benign aspects of race. Because Galt was part of the Supreme Court's larger due process revolution in which the court was looking in the 1950s at school segregation, in the 1960s in criminal procedure, as well as in juvenile justice policies. And in all of those areas, the reform of the criminal justice system and the juvenile justice system was part of the court's broader civil rights agenda. But Galt also began this process of transforming the juvenile court into a more criminal-like endeavor. In 1970, the court in re Winship said that juveniles are going to be entitled to proof beyond a reasonable doubt, and further fostered this convergence, both procedural and substantive, between juvenile and criminal courts. The court in McIver denied juveniles the right to a jury trial, and that's a critical decision, but McIver was concerned that if it went all the way to equate delinquency in criminal proceedings, it would really eliminate the rationale for a separate juvenile justice system, and it would adversely impact the informality and confidentiality of juvenile courts as a separate enterprise. But Galt began this process of transforming the juvenile court because it was focusing not on a kid's real needs, but on what they actually did. And so it shifted the focus from a welfare orientation to a more criminal one, and it also made clearer the relationship between what kids did and what they got, the relationship between crimes and sanctions. The irony is that the Supreme Court granted juveniles procedural safeguards in order to protect particularly civil rights in the interests of minority offenders, but as we began giving juveniles procedural rights, it provided a rationale for departing from the traditional rehabilitative underpinnings of the juvenile court and allowed us to start becoming more punitive, and those punitive policies in turn fall disproportionately heavily on minority offenders, so that what started out as a way of trying to protect minority youths within the justice system has had over the past several decades, the perverse and opposite effect. So I just want to describe briefly what's been happening in Minnesota over the past several decades, and several of the people in this room, have been part of this process of the criminalizing of the juvenile court. Beginning in 1980, the Minnesota legislature and the Supreme Court began a series of changes. In 1980, the first change was simply to change the purpose of our juvenile code from one that emphasized children's welfare and best interests to promote public safety and reduce delinquency by maintaining the integrity of the criminal law. And that was also where we began using presumptive waiver criteria and the rules of criminal evidence in delinquency proceedings. But importantly, the legislature in that first round of more punitive reforms did not give juveniles the right to a jury trial. And I'm going to keep coming back to this jury issue because it drives lots of other issues. Also in 1980, the Minnesota legislature adopted the sentencing guidelines. And it adopted the sentencing guidelines in part because of concerns about racial disparities in criminal justice administration and also geographic disparities in criminal justice system, that if you lived in an urban county or a suburban or a rural county, you were getting different sentences based on where you lived rather than what you did. Importantly, the legislature also included in the criminal history score of the sentencing guidelines a juvenile component. So the juvenile delinquency felony convictions became part of what could lead to sentence enhancements for youth sentenced in criminal courts. And importantly, as we looked at sentencing over the decades, the guidelines make no distinction between sentencing of adults and sentencing of youths tried as adults. There's no formal recognition of youthfulness as a mitigating factor. In 1983, the Minnesota Supreme Court addressed the problem of having different rules of court in different counties throughout the state and adopted one set of statewide rules to govern all of the juvenile court processes. And in adopting those rules, the Supreme Court sort of adhered to this traditional idea of juvenile courts as different from criminal courts. And so it made a number of policy decisions that affect administration of courts and race issues today. On the one hand, it decided to treat juveniles just like adults when formal equality means practical inequality. So we use an adult standard for waivers of the right to counsel, for example, even though the developmental psychologists tell us kids are not adults and they're going to perform less well than adults when they have to make those decisions. And on the other hand, we use the procedures of juvenile courts which do not provide the kinds of safeguards that adult criminal defendants would face, the right to a jury trial. And a jury trial is important because it's easier to convict somebody without a jury than it is with a jury. And we use these delinquency convictions to enhance criminal sentences. And the Supreme Court in McIver a couple of years ago said there's no problem with using these delinquency convictions for purposes of adult enhancements. In 1986, we opened delinquency proceedings to the public for 16, 17-year-old felony kids, and that sort of undercut McIver's rationale that we need to preserve the confidentiality of juvenile courts. When I talked about the problem of waiver, since the mid-1980s, we've been trying to figure out how to improve the delivery of legal services in juvenile courts. And when I first started looking at this issue back in the 1980s, what I discovered was that in many parts of the state, a majority of the kids going through the juvenile justice system never saw a lawyer. A third of kids are removed from their homes, a quarter of the kids in the training schools, and especially rural kids never saw a lawyer. So that what we were seeing was a pattern of justice by geography, and the pattern of justice by geography also overlay with issues of race. Urban courts did a better job of appointing lawyers, but there were still racial disparities in delinquents' access to counsel, even in the jurisdictions that were providing them. In the late 1980s, we also became much, much more aware of the issues of race in juvenile justice administration. Race as it was reflected in detention decisions, in sentencing decisions, and in waiver to criminal court decisions. When Congress reauthorized the Juvenile Justice Delinquency Prevention Act in 1988, it said we have to focus on disproportionate minority confinement, and all of the work we're doing in juvenile justice today is the result result of that OJJDP DMC mandate to look more closely at issues of race. So when we look at the role of race in juvenile courts, since the late 80s, we see that there are sort of two factors that are driving detention decisions and sentencing decisions and waiver decisions. One of those factors is the principle of offense. We define juvenile court jurisdiction based on the commission of a crime. That's the reason we're bringing these kids into juvenile court. And so when we look at sentencing decisions throughout the process, present offense and prior record account for most of the variance that social scientists can explain. The second factor is after we control for present offense and prior record, there's a race effect. That is to say, minority kids are going to be sanctioned differently and more severely than our white juveniles. The race effect stems from three sets of factors. The first is there are differences in rates of offending by race, particularly for violent crimes and gun crimes, and that's not surprising given all of the risk factors that Myron was describing earlier today in terms of growing up in poverty, segregation, cultural isolation, lousy schools, and the like. So that, that you have differences in rates of offending is not entirely surprising. The second factor that accounts for some of the racial disparities in justice administration are associated with justice system responses themselves. Attribution theory, the psychologists just described, we see people differently, and we see people differently through the prism of race. And the other component of that is to the extent we're focusing on kids' real needs, those real needs are going to differ by race, and so they're going to be subject to differential intervention. The third factor is a structural factor. Urban courts tend to be more formal. More formal courts tend to sentence more severely. Urban courts have greater access to detention facilities. People held in detention facilities are also going to have harsher sentences because of the fact of detention, and minority juveniles disproportionately live in urban contexts in which they're going to be at risk for these other structural factors that have really nothing to do with race. The second part of the story, I said race has had two effects in juvenile justice policy. The first was Galt and the decision to provide procedural safeguards. The second is the more malign effect of race on justice administration. Beginning in the 1980s and in the 1990s, we've seen the structural transformation of cities, and again, Myron's graphs about segregation in schools and poverty and the like, really describe graphically the way in which we have seen the deindustrialization of the urban core and the process of white flight to the suburbs. And it was in this context in the 1980s and the early 1990s that crack cocaine started coming into cities, and we saw the spike in homicide, particularly within the urban black community, as a result of the confluence of crack and guns, so that, for those of us who were here several decades ago, we were living in Murderopolis, which was sort of the consequence of that. And so as legislatures around the country started looking at this spike in urban youth violence, there was the impetus to get tough and crack down, and we saw that played out in Minnesota. Again, I see several of the people who were on the task force with me in the early 1990s that was rewriting the state juvenile code to deal with this perceived threat by urban black males. So that when the legislature passed its last round of substantial juvenile code reforms, it further fostered this convergence between juvenile courts and criminal courts. We used the adult sentencing guidelines to structure the waiver process, and the guidelines target particularly violence and guns, which means that it's going to have a disparate impact just by being administered neutrally. The guidelines also again, there's no provision once youths are transferred to criminal court that they're actually going to be sentenced as juveniles, and the Supreme Court has repeatedly said, once you make the transition under the guidelines, you're going to be sentenced just like everybody else, and there's no recognition of youthfulness as a mitigating factor. The second reform that the task force introduced, and it was one of the worst things I've ever done in my life, was the introduction of this EJJ provision, because one of the, I've gone around the country testifying to other legislatures telling people, this EJJ is a dead-end road that ends at a cliff. Because as we have started doing the evaluations of EJJ, what we discovered was judges continued to transfer exactly the same kinds of kids they were always transferring, but then they started using EJJ to deal with kids who previously would have been dealt with as ordinary delinquents, but those ordinary delinquents then end up getting their probations revoked and ending up through the back door to prison as a result of technical probation violations. The other thing that EJJ did, besides sending more kids into the adult system, was to expand the use of delinquency convictions in the criminal history score even more, so that we're now bumping them up from 1 point to 2 points or more. Because we recognized that we were making the juvenile court even more punitive, we included provisions in the law reform to improve delivery of legal services and to make it mandatory for kids to have lawyers, at least when they're charged with felonies, and for the serious misdemeanors that remained that the legislature didn't convert into petty offenses. And I just finished using some MNCIS data this last year to evaluate the impact of these law reforms on delivery of legal services. And what we discovered was that there was some reduction in justice by geography. That is to say, we improved the delivery of legal services in rural counties as a result of giving the public defender statewide authority to provide representation. But at the same time, there are still a substantial proportion of youths who are going through the justice system without access to counsel. It's about a third. I mean, a third of kids charged with felonies and serious misdemeanors are going through the system without access to counsel. So, as I have thought about all of these issues, and I've been thinking about these for decades and decades, it seems to me that there are three kinds of things we need to focus on. I mean, the first is data collection. You can't know where you're going till you know where you are. And the most critical data points that we need to be collected are race data. And I was sort of distressed when I heard Judge Bransford talking this morning about, and we're not collecting juvenile race data. That is a critical. I know you're doing it the self-report, but the self-report, you don't get adequate compliance. I mean, what we found when we were looking at the MNCIS data earlier is that once you get out of Hennepin County, you can't do race analysis in the state because we don't have systematic data collection. And the Race Bias Task Force made that same observation, that we just don't collect race data systematically enough to be able to think about race and justice policy. The second data point that we need is detention. And I was again distressed when I was doing research using MNCIS data earlier. Detention was one of the boxes you had to check off, whether a kid was being held in detention or not, and that actually got eliminated between 1994 and 1999 from the coding sheet. The third variable is whether or not kids have access to counsel, because whether or not a kid is represented is going to affect many other aspects of the justice administration process. And what we need with respect to counsel, as well as these other data points, is a way of monitoring it in real time, so that as soon as we see boxes not checked, there needs to be a flag that goes back to a county court administrator saying, where is the lawyer, or where is the race data, or where is the detention status? Because trying to do analyses about data several years later, I mean, from my point of view, that's fine. I can analyze data whenever it's based. But in terms of actually providing a justice system, you need a justice system that operates in real time, and it shouldn't be that hard to create data flags that for automated purposes that we're missing this. The second, and again, we saw the presentation this morning about the marvelous impact of JDAI on reducing rates of detention overall and the use of risk assessment instruments. And obviously that needs to have a broader application throughout the state. But it also suggests a separate question, which is that we got the original Minnesota sentencing guidelines exactly because we were concerned about geographic disparities and racial disparities. And JDAI is a way of thinking about sort of a guidelines approach to dealing with these issues. But we may need to think more broadly about dispositional guidelines for juveniles on a statewide basis, and recognizing there are going to be differences in resources available in different parts of the state, but again trying to make more objective and measurable the components that go into dispositional decisions to try to get a handle on the race effects. The third point is, I've mentioned earlier that it's easier to convict kids in juvenile court than it would be an adult in a criminal court in front of a jury. And this goes to the issue of the delinquency component of the criminal history score and the extent to which there may be a race effect, because race effects compound and accumulate. Every discretionary decision of every person in the justice system over time becomes part of these criminal history scores. So that to the extent we see minority kids picking up criminal history points at greater rates than whites, that may be a result of differences in rates of offending, but it also may be a result of racial differences in juvenile justice processing over time, and these kids ending up in the criminal courts with higher criminal history scores may have a disparate impact, even though it looks perfectly neutral. So that's where I end up. We need more and better data and collaborations in order to do this kind of research in a closer to real-time context. We need to think about objectifying dispositional decision-making throughout the process and throughout the state, and to look at the use of delinquency convictions to enhance adult sentences. All that in 20 minutes.
We have time for one question. Anybody? Okay. So your concept of mitigating sentencing based on youthfulness, I'm wondering if there's been any real attempt to get legislation changed in order to do that?
Well, let me just sort of back up. I've been arguing for a youth discount for, about 3 decades now. I call it short sentences for short people, as a way of recognizing that, what the Supreme Court told us in Roper, that adolescent brains are different, that their impulsivity is different, that all of the things we know about why kids are kids and therefore do stupid stuff, we now have neuroscience imaging to show it. And the Supreme Court in Graham v. Florida last year, again, recognized youthfulness as a mitigating factor. We have seen some very, very modest changes. States that previously were sentencing juveniles to life without parole for homicide are now making them eligible for parole consideration after only 40 years, which is not my idea of youthfulness as a mitigating factor, but it's at least a recognition of differences in degrees of culpability. But we really need to start focusing. Again, I kept hammering this kids being tried as adults, and under Minnesota law, a 14-year-old convicted of murder 1 gets life without parole. And there are developmental, neurological, qualitative differences between the decision-making of 14-year-olds and 24-year-olds that a legislature can take into account. I mean, it can take it into account in the context of guidelines. I mean, I've just argued for discounts on sentences, taking account of age. So what we see is, at least in the LWOP context, there's been a little bit of movement, but otherwise, nobody wants to be soft on crime, and, you know, giving a kid only a 50-year sentence, somebody's going to construe as soft on crime. So we have a lot of progress to make. Thank you.